You're the Robbie Crystal Petrie consultant, so inspiring, pushing you to your dream.
Hello, and welcome to another episode of 60 Minutes With. I'm your host, Crystal Petrie. Today, we are going to learn all about wills and estate planning. I know, when most people hear those terms, they think about death. But on this podcast, we're going to explain to you how actually a will and estate planning is all about the living. And here to educate us about wills and estates, Sara Norman.
Thank you so much for having me, Crystal. I'm really excited to be here.
Thank you so much for agreeing to do this interview because, like I stated, I feel like when people hear the word will or hear the word estate planning, they automatically think of death.
Right.
And as I was doing this and preparing for this interview, I was like, that's really not the case. It's really about the living. So my first question for you is, what is a will and what is an estate?
Well, a will is the written document where you identify your assets, who you want to be in control of those assets when you pass away, and what you want to happen to those. The truth is, I don't know if this is a secret, you're going to die. I'm going to die. Everybody is going to die. And it's time to just admit that it's going to happen. And you know, you've always heard of failure to make a plan is a plan to fail.
Yes.
That is never more true than in estate planning. And unfortunately, whenever it fails, you're already gone. And your family is the one left to pick up the pieces, try to put this puzzle together, and make the best decisions that you really could have taken care of while you were alive. So I love what you said, that wills and estate plans are for the living, because they are. Not just for you as the one drafting it, making your plan, but everybody you're going to leave behind. And that's really the most important part about an estate plan, is thinking of who else is going to be left dealing with everything.
Right. And you know what? You have already educated me like 10 seconds into this interview.
Because we're done.
Yeah, I know. Goodbye. Because I did not think about it like that. So you were saying, you know, when you fail to plan, you plan to fail. But after you've passed on, the failure is there and there's nothing you can do about it. Like you can't fix it.
I know.
Oh my goodness.
And that really is kind of, I would say, one of the most challenging parts of my job is sitting with a family and telling them that it could have been much easier. You know, they're dealing with the death, they're grieving, and now they're needing legal advice, they're needing representation, and it is my obligation to tell them this could have been done in a completely different way, and that's what we would be working with, but instead we're doing it this way because I want to educate them for their own estate planning needs.
Right.
I feel like a lot of my estate planning clients are my probate clients first. So probate is the process that you go through when someone passes away to administer an estate. You know, earlier you asked what an estate is. Right. An estate is what is left after you pass away. So everybody has one, whether you have a will or not. A will tells people what you want to happen to your estate.
Okay.
And if you don't have a will, then the state of Texas, where we live, dictates what happens to your estate. But it still has to be administered, stuff still has to happen, and it's more expensive, honestly, when there's less of a plan. Does that make sense?
Yes.
It sounds very morbid and complicated, but it's really not. Texas is truly a great place to live. We have a great infrastructure, we have a great set of laws, and it's honestly a great place to die. There are other states in the United States that have a very complicated probate process. Texas really doesn't. They make it very easy for family members, executors, and administrators, we'll talk about those in a minute, to figure out what to do with an estate and to help them move through this process quickly and efficiently.
I'm definitely going to use that little quote, Texas is a great place to die.
It is.
We need to put that on a billboard.
I know,
or
right? I've been saying that I should be on a billboard.
You should be. You absolutely should be. Okay, so assets. What are assets? So would that be like your house, money?
Exactly. Anything that you own. And a lot of things you kind of forget that you own. Intangible things like your 401k, you own that. Bank accounts, life insurance policies, you don't really think about that, but that's a huge asset that is going to pay out at your death. You can make a plan for that. Most people have, at the very least, a bank account, a place they live, and the stuff inside of it, and a car. And
Okay.
I do hear a lot from people that say, well, I'm not rich, so I don't need an estate plan. But remember, if you don't make a plan, stuff has to happen to that stuff anyway. And it doesn't matter how much stuff you have, things still have to be transferred in ownership. And
Right.
when you don't set someone up for success in that transfer, and they're kind of doing it based on what a court says they have to do, based on what the law says they have to do, it takes much longer. You need an attorney to do it. Attorneys charged by the hour, so it ends up being an expensive process
Right.
to get a very small amount of assets out. Does that make sense?
And I feel like that adds to the grieving process because you're already sad, you're already grieving that mom passed or dad passed or your spouse passed, and on top of that, now you have to deal with this other stuff, you know, who
Right.
gets the house, who gets the car, who gets the 401k. And what happens, like, if you have money in your bank account and there's no will, there's no estate planning, what happens with that money?
Okay, there's two ways that accounts like that can be transferred. They can be part of your estate, meaning they had no designation in their written documentation about what happens.
Okay.
Banks usually when you open a bank account, they give you that one piece of paper and they say, sign here, check this box,
Yeah.
and you never see it again.
Yes.
That piece of paper is very legally significant.
Okay.
It tells you the kind of account you have. Is there a payable on death designation? Is it jointly owned with right of survivorship? So if you're married and both of you are on an account, you can set it up as jointly owned with right of survivorship, meaning if one of you passes away, the other one who survives is the sole owner of that account automatically, without going through probate, without going through a will, and even if you write something different in your will, that document at the bank controls.
Really?
And so there are a lot of people that don't know that, and they kind of get themselves into a little bit of a bind because they signed a piece of paper 20 years ago. They made an estate plan and a will, but never actually changed anything or checked. And that's where a competent attorney is going to walk you through why you're doing the things that you're doing. Does everything add up to the same result? So we call it like belts and suspenders. You do
Okay.
everything two ways to make sure it definitely goes the way you want it to be. Does that make sense?
Yes.
It's interesting, and there are a lot of people who, when they open a bank account, whoever is helping you set that up,
They don't say anything.
they don't know. They're not lawyers, so they really can't give you advice on it.
Yes.
And life happens. Things change. You might get married. You might get divorced. You might do all kinds of things.
Yes.
And you would want to update that information periodically to make sure that it follows. So if you have a bank account that has a payable on death designation, a beneficiary listed, it's jointly owned in some way, so someone else's name is on it,
Okay.
or it has a right of survivorship, those kinds of things are going to control what happens to all or part of that money. Okay. If you are a sole owner of a bank account, it doesn't have any of that stuff, it's not listed anywhere, it goes as part of your estate. So a will would control that, and if you don't have a will, it's going to be through probate, and we call that an administration. So, like, imagine this, and this has happened, unfortunately, to clients of mine before, where they had an elderly parent who passed away. They were living somewhere else or living at home with their children. They didn't drive anymore. They had a 401k that had a beneficiary on it, just rolled over to somebody else, great.
Yes.
And then they had a bank account with $20,000 in it. That's great news. They
Yeah.
did not have a will. They didn't list anybody as a right of survivorship or payable on death. And now these clients have to open an entire probate administration, which is much, like I said, longer than like a will administration, just to get this amount of money out. And when you think about it, in the grand scheme of life, $20,000 is not that much. I mean, it's a lot to me.
It's a lot to me too.
But when you think about the time, the effort, and the cost of getting that out,
wow.
I won't say it's not worth it, because it is.
Yeah.
But trust me, everybody's upset about it. I hate
goodness.
telling my clients, like, if they had just, talked to someone
Yes.
and set up a payable on death designation on that one account, everything else will be taken care of. Instead,
Wow.
they're going to have to hire an attorney. They're going to have to go through the first part of an administration, which is determination of heirship. Then comes appointing an administrator. Then the administrator goes to the bank with a court order, The bank releases the money to the estate of. The administrator has to open a bank account, cash that check, distribute that money according to the heirship determination that they already had.
Yes.
And then you can close it. That takes
What?
months and months, court dates, court appearances, witnesses, testifying witnesses, and when you hear all that, think attorney's fees.
Oh,
Okay?
yes.
And I mean, I know I shouldn't say this, but I don't want to make money on probates. I would rather help people prepare a comprehensive estate plan so that they can not have to worry about that at all.
Yes.
Probate, like I said, Texas is a great place to die. If you do have to probate a will, it's not the end of the world, and it doesn't take forever, and comparatively, it's not that expensive. But what's frustrating is when people have this one asset, and they have to go through all of that work for this one
Yes.
asset. You would have to do that exact same process if there were $20 million somewhere. But for $20,000, for $2,000, that's what we'd have to do.
Yes.
And at some point, some people really consider, well, how much does the filing fees, the attorney's fees?
It's like leave the money.
Yeah. Do you just walk away? And there's a point where yeah. I know, and it's frustrating to me, and like I hate telling people this.
Yes.
After the fact, but I want them to know, like, go to the bank, check your bank accounts. Check your life insurance policies. Do you have a beneficiary? Do you have a plan? Did you have children since the last time you started? Did you get married, divorced? There's so many things that can, make an impact on that. And people they don't want to think about it.
They don't want to think about
Nobody wants to think about dying.
They don't want to talk about death.
I know.
But like you said, it was breaking news.
Yes, you heard it here first. Yes.
Everybody is going to die.
I hate to be the one to tell you, but it's
breaking
true.
news right here on the podcast.
I know.
So why is it that the statement at the bank where the survivorship and everything that you check or you don't check because no one tells you about it, why does that take precedence over like the estate planning and the will?
Oh, that's a good question. Okay, so that is actually a contract you have with you and the bank. Okay? So you as the owner of the account say, I want to put my money here and this is what I want to happen with my money. Okay. And once you have that contract, that written agreement, that is stronger than the written agreement you have with yourself, which is your will.
Okay.
So it removes that asset out of your probate estate and it just becomes a contractual asset, meaning something that you signed controls what happens to it. Same thing with life insurance policies. If you designate a beneficiary, you have contracted with that life insurance carrier to do something for the premiums that you pay.
Okay.
Now you can have a life insurance policy and no beneficiary, and what's going to happen is that life insurance policy will only pay out to the estate of. You cannot cash that check until you have a court order. You cannot get that court order until you go to court and do the heirship and the administrate. You see?
Yes.
It really adds up. And there is nothing wrong with doing an administration if that's your plan. Some people, that is the plan. It's not very common because that would mean you had a plan but it didn't include a will.
Right.
It's so much easier to write it down. Something I think that people don't really consider the difference between what happens with a will and what happens with an administration, just a regular state administration, is who's in charge.
Okay.
If I'm married, I have a child, my will says that everything goes to my spouse. If I died without a will, guess what? Everything would go to my spouse.
Okay.
That's the way the law works in the state of Texas because we're community property. It's the only marriage I've ever had. My child is a child of that marriage. That makes a difference.
Okay. And we'll get into that.
And we'll get into that, yes. But it would shake out the same way.
Okay.
Okay. But the administration side, with the heirship and the appointing administrator, that's the second part of the administration. Okay. When you have a will, you list your executor. So you get to decide. You help the court decide, right now, I want this person to be in charge.
So the executive is the beneficiary in the will?
No, not always. Sometimes you're going to have really 3 different people at some point in your estate plan, probably.
Okay.
You're going to have the executor. That's going to be the person who's in charge of gathering all your assets after you die, paying all the debts, and then distributing your assets according to the will.
Now, would that be the lawyer or can that be anyone?
No, that's anybody. Yeah,
Okay.
your executor hires a lawyer to help them.
Okay.
But your executor is someone you know, someone you trust, okay?
Mhm.
A lot of people do choose their spouse or the adult sibling to be their
Yes.
executor, and likely that person is also going to be a beneficiary of the estate.
Okay.
But they don't have to be the same.
Okay.
You can also designate within your will a trustee if you're going to set up a trust within your will. That's a little bit more of a complicated estate plan, and
Mhm.
if we have time, we can talk a little bit about that. But there are so many ways to do it. I think the most important thing is that people get in front of an attorney that they trust, that they are comfortable talking to, and ask these questions.
Yes.
You know, and talk through it. What do you want to happen? Who's in your life? Who's involved? Who's a troublemaker? You know, that's important.
Do you put that in the will?
You don't say you're a troublemaker, but
But-
you can exclude people.
Yes.
You know, it's your money, it's
Mhm.
your property, it's your assets. You can do whatever you want. You can give it all to your cat if you wanted to.
You know what? Someone did that. And
Yeah.
did they give it to their dog?
Yeah, you get a pet trust.
Yes.
I've only had to write one of those in my career.
You really?
Yes. And that was the best thing for that particular client. We talked about it extensively.
Yes.
For a horse, actually.
A horse.
Uh-huh.
Now, of course, we can go down a tangent with
Yeah,
this.
I
I'm
can
just
give
gonna-
you some crazy
Yeah.
stories, but I won't.
I'm gonna ask you one question regarding the horse.
Mm-hmm.
Okay, you give all your money and leave everything to the horse, which is an animal.
Mm-hmm. It's more of a trust for the care of the horse. So the
Okay.
person can't really spend it on themselves. So they have a job now, they're taking care of a horse, and they have the funds to do it, but they have
Yes.
to do it because that's what the will says.
Okay. Okay. Who needs a will?
Everybody.
Everybody.
Everybody. Because like I said,
Mhm.
no matter what happens, you are going to die.
Yes.
And then you're going to have something to do after the fact. That, the will takes care of the something to do. Now, you don't have to have one. You know, there's no law that says you have to have a will before you die.
Yes.
There's a lot of people that die without a will. But after the fact, things are still going to happen. It is so much more complicated, so much more expensive, and so much of a longer process when you do not have a will, or at least a comprehensive estate plan. Now, there are some ways, and this is an important conversation to have with your attorney.
Okay.
There are some ways that you can make an estate plan that includes a will, but that you would never have to probate. So, for example,
Okay.
let's say that you have your house, you have your bank accounts,
Mhm.
and you have a vehicle, and that's all that you have, okay? And you meet with your attorney and you talk about these assets, and you talk about where you want them to go. You have decided in your mind who the beneficiary of your estate would be, and
Okay.
say it's one person's gonna get all of the same stuff, okay? All of those assets are able to, with our contractual agreements, set up to where they will transfer at your death. Okay? Now, I would also recommend to those clients that you simultaneously execute a will that says the same thing.
So you need both. You need a
Mhm.
will and the estate plan.
The estate plan
Okay.
is the umbrella,
Mhm.
a will is part of it,
Yes.
okay? And we're
Yes.
talking about the other documents in an estate plan,
Mhm.
but I think that is the biggest difference between someone saying, I need a will, I'm gonna Google a form online, please don't. Because some people don't realize a will might not be the best way to get all of those assets transferred, the quickest and the cheapest.
Okay.
Okay? It is talking to an attorney that's gonna tell you, here's what we can do now, and then we draft this will that says the same thing in the event something else comes up. So, for example,
Okay.
let's say you have all these assets and you're like, that's all I have. I've set it up to where they all transfer on death, and there's different mechanisms for all those. An attorney can walk you through that. But then you buy a lottery ticket and you win. And you
Yay!
die. And you have a heart attack and die. It's so good. Well,
Yes.
see, you didn't make a plan for that because you didn't know you had it. The will
Yes.
would pick up anything that happened that you were not expecting. An unknown asset. You know, because you don't want to have to, again, go through the whole process.
Yes.
Because you definitely want to cash that lottery ticket.
Definitely.
So you want something, like I said, the belts and suspenders. It does, they both hold up your pants. They just do it two different ways. Okay?
Yes.
And talking through your assets, and more importantly, what you want to happen to your stuff, no matter how much stuff you have.
Okay.
That's the important part. And then deciding which of those assets can be taken care of while you're living, which of them are controlled by the will, what's the best way to do it, and truly the most efficient.
Oh my goodness.
Is it exciting?
It is.
It is. I tell people all the time estate planning is so exciting, but they don't
Oh
believe me.
my
I know.
God, it's so exciting. Here we go.
Okay.
So we have established that like doing probate and everything after death is very expensive.
Mhm.
How much does it cost to get a will and estate planning done while you're alive?
Okay, well, every attorney is different. There are two ways that attorneys usually charge for this type of thing, hourly, or if they have a flat fee option.
Okay.
So typically for my estate plans, I have a flat fee option for single individuals. It's around $1,800 for one person. Okay. And then for a married couple, it's $2,800. Those change year to year. There are definitely attorneys that can do them more cost effective. There are definitely more attorneys that can do it on a more expensive side. It depends on what you, the client, are comfortable with. The legal industry is a service industry. We work for you. So you as the client have the right to choose whomever you want to work with and to have a cost that you're comfortable with. Okay. There's a lot of great attorneys in this area and in the state of Texas, and any attorney in Texas can draft a will that covers property in Texas. So you just got to find the right fit for you. For probate, when you have a will, it's, I would say, less expensive than doing the administration, because the administration has two parts to it. The heirship determination, it's just a different court proceeding that's required, and then the administration. Okay, so the will takes out that heirship determination and kind of streamlines the process. You still, and those are hourly, and in my practice. So they're still meeting with the client, reviewing the document, preparing for court, attending court. That adds up, of course, but it's faster with a will than without a will.
Should a will and this is two questions. Should a will and estate planning be done together always, or can it be done separately?
Well, I said it could be done separately, but should it? No. Because remember our example about the bank account? Preparing a payable on death designation in a bank account, that's part of an estate planning process. That's not part of the will. And if you do some of these things and then meet with someone to draft a will, or you draft a will first and then do all these things, the plan is not going to match. Your attorney can only help you when she knows all the information that you know. That's why I've said this before, and I will say it like 10 more times in this interview, meeting with your attorney is so important. There are, the internet is wonderful for a lot of different reasons. There are fill-in-the-blank templates that you can get that are, I wouldn't say they're good. Some of them are okay, some of them are valid, some of them aren't, but you will not get the benefit of talking one-on-one with someone who's there to listen to just you, to hear about your assets, to hear about your plan, to hear about your concerns and your questions, and to be able to walk you through those decisions, right? And there are even attorneys who are very effective that do all of these things, over the phone. I don't do that. I find that when you sit with someone and you talk to them for an hour or more, you pick up things that maybe they didn't know to bring up. The conversation is where you get to know your client's needs and their wants and maybe their concerns. And a good attorney wants to protect all of those things.
Absolutely.
Yeah.
How often should, say someone has their will, they have their estate planning. How often should they update it or at least meet with you to read over it?
Right. Well, I think that people should review it pretty often. I think a lot of people are like, I did my will, I never have to think about it again. And you don't have to. Whatever you wrote down, that'll work. You just might have changed your mind between them. So try to remind yourself what you decided and why. And then I always say that any big life change is when you should review your estate plan generally. You get married or you get divorced, you have a child, you have a grandchild, you retire, those, your children move out of the house. Those are big life stages that change what you might want to do with your estate plan. So if you have minor children, your plan is going to be a little bit different than if you have adult children who are married with their own kids.
Would it be in the will or in the estate planning? If you have minor children and something happens to you, or you and your spouse both die at the same time, where would that information go?
Okay,
Because that's survivorship, right?
Well,
No?
yeah, we're yes and no.
Okay.
Not like where the kids go.
Yeah, that's what I'm asking.
Okay.
So where would we put that?
Okay.
Where would my kids go if me and my spouse pass?
Okay, well, let's back up to the estate plan. Remember I said it's an umbrella?
Yes.
Okay, so there are many documents within an estate plan, and a plan is just a plan.
Yes.
The plan is only effectuated by the documents that you have to do the things you want them to do. Okay?
Right.
So in your estate plan, you have a will. The will is going to say what happens to your stuff, mostly. Okay.
Yes.
But there are provisions that you can put in a will about your minor children, their guardianship, their custodial guardianship. If you and your spouse are both deceased, their other parent is deceased. But that can be in a standalone document as well. Okay. So when I do my estate plan, okay, and this is included in my flat fee price, and I only do it as a comprehensive estate plan because I don't want people saying, I only want to pay for this and I only want this document. I truly believe that every single document is vitally important, and I just won't let my clients walk into a situation that could have been prevented by one of those documents. So I only practice with a comprehensive estate plan. That's just my personal preference. Like I said, there are all kinds of great lawyers who do it differently, and that's totally fine. For me, I think meeting with the client, discussing the plan, and then telling them what goes into an estate plan and educating them helps them see the value of each of these individual documents.
Okay.
Right? So you already know a will, very important.
Yes.
A will dictates something after you've passed away.
Yes.
Okay? There are all kinds of things you can do while you're alive and that still might be essential to you. And I know these are part of the questions that are coming up, but we'll just get right to
Yes.
it. Okay.
Yes.
Your power of attorney. That is part of your estate plan. When I do an estate planning package, my recommendation is that there's a will, a medical power of attorney, a statutory durable power of attorney.
Okay.
That's for your financial power of attorney. A directive to physicians, that's like a living will.
Okay.
A HIPAA release, and a declaration of guardianship for your minor children if you have them, and a declaration of guardianship in the event you are incapacitated. Okay. There's a lot of documents, but again, it's clients need to understand that each document serves a purpose. The documents themselves can save so much time and so much anguish in the event they need to be used, right? And that's why a good attorney will sit down, talk to you, and explain all this to you so that y'all can make the decisions together.
Okay, so let's go over exactly what some of those documents are.
Okay.
So let's start with power of attorney.
Okay.
What is that?
Okay, there are two powers of attorney,
Okay.
a medical power of attorney and a financial power of attorney. There's so many decisions that can be made regarding medical decisions and financial. It's too strong to be in one document. So in the state of Texas, they are separate on purpose, okay? Your medical power of attorney directs somebody to be able to make decisions in the event that you are unable to communicate your own medical wishes.
Like if you're in a coma.
Right.
Okay.
Right. A surgery, elective surgeries, or a course of treatment that maybe you don't have the opportunity to consent to. You can direct someone to be able to make those decisions for you.
Okay. And that's the medical power.
That's the medical power of attorney.
Okay.
A good example of when that would be, that's not a morbid example, but a good one that actually comes up a lot is, let's say that you go in for surgery of some kind. While they're in there, they see something else. It's much more dangerous to bring someone out of anesthesia, close them up and say, hey, while we saw this,
Yes.
It would be very easy to talk to whoever was appointed as their agent and make that decision with your physician.
Yes.
That's just one, it comes up a lot, and that's one example that I've seen them be used effectively. And again, this is what your doctor has recommended. I'm not a doctor, I don't know anything about that, but that's one opportunity where you can use the medical power of attorney effectively.
Okay. And the financial power of attorney.
Okay, the financial power of attorney, the full name is the statutory durable power of attorney.
That's a mouthful.
It is. But they're the same thing. Financial power of attorney, statutory durable power of attorney.
Okay.
That's going to be everything that's not medical. assets, real property,
Okay.
intangible assets like bank accounts or investment policies. There's so many things that a statutory durable power of attorney can help with and control, and it's a very, very powerful document. I always say that you really want to be cautious about who you choose to be your agent because they're going to have
Yes.
access and control over potentially a lot of your assets. So the statutory durable power of attorney, it's the reason it has that name is because it's found in the statute, the estates code.
Okay.
And there are lots of ways that you can structure your financial power of attorney. Your attorney will walk you through what you want to do, what powers you want to grant, or maybe ones you want to withhold. And that just depends on what you're comfortable with and the assets that you have. So that you would put somebody in charge of those kinds of assets, and you can make it effective when you're incapacitated, or you can make it effective immediately. An example I use a lot for people who say, why would I need it immediately? If you want let's say you own a piece of real property, a vacation home, and your name is the only one on it, and you're out of the country, and you want someone wants to buy it, and you want to sell it, and you want to sell it quickly. Well, someone has to be able to sign that deed on your behalf. Your agent, under your power of attorney, could effectuate that transfer for you if you wanted them to. So, there's a million examples you could use, but some real world that actually comes up. That one is one.
So the financial power of attorney, that could be whether you are alive or you have passed away.
It's only if you are alive.
Okay.
So your will covers when you are dead.
Okay.
All these other documents are about when you're alive.
Okay.
Except for where your children, like the guardians for your children, of course, you have to be passed away for that.
Okay, so the guardianship papers. Let's talk about that. What exactly is that?
So you can direct who you would like to have custody of your children, to be the guardians of your children, in the event you and their other custodial parent is deceased. So people ask me, if I'm divorced, can I direct that someone besides my ex-husband gets my kids if I die? Well, no.
You can't?
You don't get to, if he's still alive and he has joint custody, he's going to have full custody because you're not there anymore.
Okay.
So you don't get to circumvent someone else's parental rights just on a piece of paper. Okay. But you can say, in the event that he's gone and I'm gone, these are my wishes about where I want my children to live and who I want them to live with.
And do both parents have to agree on who the children will go to?
I think that would be wise, because anytime there's a question about what really is in the best interest of the child, you're going to have to get a court involved. And if you have two parents saying something differently, that might be an opportunity for someone to say, well, I'm not really sure which one is going to be the best fit, so you're going to have to bring in kind of a third party to help make that decision. I do think it's best, honestly, if everybody agrees, we're all on the same page.
Yes.
It's obviously much harder whenever you have, children with someone that you're not married to. That complicates things, but it's not impossible. It's just a conversation.
And do both parents need to come in and see you? Or how would that...
Are you talking like a married couple?
No, like divorced or not together.
Well,
they have the kids.
Right.
Do they both need to come in and see you?
Every client has their own attorney-client relationship. Okay. So you and if you have an ex-spouse or something, y'all can have different attorneys.
Okay.
And you probably do. If it didn't work out, then you probably see different people anyway. That's okay. Again, you just want the plan to be the same. You want to have a conversation about it. There are family law attorneys that really specialize in making sure that there are comprehensive plans available for children when they have divorced parents. I'm not a family law attorney, but there are wonderful practitioners who can help you walk through that, and they can do that alongside an estate planning attorney.
And a living will, what is that?
That has two names. It's a directive to physician. And that tells your physician what you want to happen in the event that there is a terminal condition in which you are not expected to recover, or if there's life-sustaining equipment that's needed to keep you alive, without which you would pass away. So, breathing tubes. It's It's a very weighty document. It's a very weighty decision. And the way that that form is presented, it's really like a initial next to if you want the plug pulled or initial if you don't.
Oh,
It's
okay.
real, and it's so jarring
Okay.
to see it like, okay, well that's kind of a big decision to just initial next to.
Yes.
But I will tell you, it's something you want to think about. If you have the opportunity to make this choice for yourself, think of what a weight you will take off of someone who might have to make that choice for you.
Yes.
Your medical power of attorney, for example, has, the authority to make that decision. How much easier would that decision be if they already knew that you considered it and made a choice?
Yes.
Okay? So again, the estate plan is really for the other people in your life.
It is. It's for the
It
living.
is. It is. And so, people are like, I don't have any stuff. I'm like, well, do you have anybody you love? That's what your estate plan is going to help. That's who it's going to protect. And that's why it's really important. And honestly, it's worth the investment. We pay insurance premiums because we know, okay, when something happens to me, I want these people to be taken care of. That's an investment in somebody else's future when you're not around. Estate planning is really the same thing. It's an investment in someone else's future when you're not around.
If you don't have like the living will, the medical power of attorney in place, does the doctors just make that decision?
No, they go to, there's a whole body of law about how you're going to determine that. But I think, everybody's seen the news, and this is not in Texas, but, where there's parents of somebody in a coma and the spouse of someone in a coma and they disagree.
Yes.
Right? And just think of how awful it is for those people.
Yes.
Make the decision. Decide who the doctor is going to ask. Who has the number one authority to make the decision on your behalf? Is it your spouse? Is it your mom? You want to let them know if they think it's them, but it's not going to be them. Tell them they have a right to know that you've made a plan, you've made a decision, and you think it's for the best that this person is going to be the one to make that decision if the time comes.
So that's my next question.
Okay.
When you have a will, you've done all the planning. Do you sit down with the people, like the family and friends that are in the will that have the medical power, and let them know and have the conversation? Or is it just like, well, I passed away, here's the documents, I'm done?
You can do it however you want to.
Okay.
Every client gets to choose how they, let people know. If they let people know. There are people that say it's a conversation that I don't want to have. It will, people be upset. It will cause questions that I don't want to answer. So I'll be dead. I don't care.
Yes.
That's okay. I think the kinder thing to do is to let people know what's coming. When you think about grief, and someone has lost someone that they really care about, the last thing you want that person worrying about is if they didn't really know what you wanted. If they had an idea about what they were sure that this is what my parents want, and then the document says something differently, how is that grief going to wrestle with that truth? And and that's what it's a we're talking about money and we're talking about death, and those are some really concrete things, but let's talk about people. Let's talk about feelings. You want to explore all that. It's okay if you say, I don't care about these people's feelings, or I don't want to consider it. That's okay, but I think it's worth the thought process of, do I want to help out in this way, or do I want to keep it private? It is completely up to the client. There are people who have really, really, really good reasons why their estate plan is completely private, and then after they pass away, then their executor has custody of the will and then lets the beneficiaries of the will know how it's all going to shake out. There are people with great reasons for that. There are also people with great reasons that bring their children, their adult children in and say, this is what we're doing. This is what your mom and I have decided and how it's going to happen. And this is the attorney that drafted. I've had family meetings before, clients that wanted to do that, just so if their adult children wanted to ask questions, I was there to do that. And that's absolutely fine.
Yes.
There's 100 different ways to do it. It really depends on what you as the client want to do.
Okay. Is there an age like minimum, I guess, to getting a will and doing estate planning? Do you have to be at least
18.
18?
That's a good question. I don't get that very often. But yeah, if you are a minor, you don't have the contractual capacity to direct the way things are supposed to go, right?
Okay.
Typically, if your minor child passes away, it goes to your parents anyway, and there is an administration opened because they're not able to execute a will. So children under the age of 18 can't make a will.
Does a will expire?
No.
Does the estate plan expire?
Oh, that's another good. I don't get that very often. I'm so glad that you asked these questions.
Hey.
And we were talking about this before the interview
Yes.
started. That I do this all the time.
Mm-hmm.
Obviously, I'm excited about it. I think it's a great and very interesting practice area.
Yes.
But I deal with it.
Mm-hmm.
People who don't deal with it all the time, they just don't have the same thought process.
Exactly.
Of course, and
because you're in it.
Mhm.
Yeah.
And sometimes I really do forget that you have to break it down into small pieces, and there might be questions that, I assume people know that they don't. So I'm so glad you're asking these questions.
Thank you.
There are no dumb questions.
Yes.
These are great. Obviously, I love talking about it. I love educating people on this.
Yes.
So I'm really passionate about it. So thank you. Okay, so it doesn't expire.
Okay.
It might be that the plan that you made is not really what you want 50 years from
Right.
now, and that's why you should periodically review it.
Right.
Make sure whatever you want is still what's written down.
Mm-hmm.
A huge life event hasn't changed your plan or changed if someone that you left your entire estate to has passed away.
Oh yes.
You're going to want to update that.
Yes.
Now, in a good estate plan and a good will, it talks about in the event that this person has predeceased me, then this happens, and then this happens, and your attorney will walk through all that with you.
Mm-hmm.
But generally, no, it doesn't expire. You can revoke it at any time. So if you're the one who made the will, you're what's called a testator, then you have the right to change your mind. And you can change your mind by executing a new will that says, every will I wrote before this, disregard. You can destroy the will, and that will practically revoke the will. Tear it up, burn it, scratch through it.
Okay.
Yeah, so I do have some people that come in to see me that they've had a will that they had drafted decades before, and they have the original, and they bring it into me, and they've written all over it things that they want to change.
Oh, okay.
And so I work really quickly to get a new document drafted that they can sign, because they've effectively messed up a lot of their will by scratching through things.
Yeah.
And if you scratch through enough of it, you've revoked the whole thing. If you change a bunch of it, you can really mess up kind of the intended consequence. So generally, I wouldn't recommend writing on your will unless you want to revoke the entire thing.
Who keeps the will? Do I keep it, or does my lawyer? Would you keep it?
It's up to the lawyer and the client.
Okay.
The way I typically offer my clients that I keep their wills at my office, usually in a fireproof safe, mainly because people don't like to keep up with those kinds of documents. But they belong to the client, so it is up to you. They're yours at any time. You can get them. You can take them home. Just don't lose them.
Okay.
You can probate a copy of a will. That there's another step to that. It's a little bit more complicated. But the nice thing about this day and age is you're drafting and executing a physical document. Okay. Of course, I scan that document. I make a copy. I make a copy for me. I make a copy for you. I digitize it. I email it to you. It's wherever you want it to be.
Okay.
No one's gonna say I don't remember what I wrote in my will, and dang it, I can't find it.
Yeah.
I don't know how to find it.
Yeah.
It's somewhere. And that's the nice thing about digitizing things. So it is a safeguard, but you want to probate the original document. That's the most efficient way to go through a probate. With a will is the original document.
And can a will be appealed? Like, the person, maybe they're living, but maybe unconscious, maybe they passed away. Can it be appealed?
What a will can be is contested.
Okay.
So someone has to have passed away for a will the conversation to even start. Because once someone has passed away, then you submit a will to the probate court, and that's how you get the authority to act under the will. So that's step one. Someone has passed away. But then when someone is offering a will and saying that this is a valid and enforceable last will and testament, anybody who is interested in the estate, meaning someone who would have a right to a portion of the estate, if there was no will, or perhaps as a creditor of the estate, or as a beneficiary listed in the will, but it doesn't get what they think they're supposed to get, they can contest the will. There are a lot of ways to contest a will. It's usually undue influence, meaning that somebody forced someone to write a will. That's really hard.
Isn't that hard to prove?
It is hard to prove because your star witness is dead, right? So it's difficult. It's not impossible. You know, there are lawyers who do probate litigation all the time, and I think that is a really important, you know, kind of a good example about why you'd want to discuss it with everybody. Because again, if you are sure, my dad wants me to get everything he told me to my face, and then you see a document that says something differently, the first thing you're going to think of is like, is that real? Was I mistaken? Was he mistaken? Did he change his mind and not tell me? Did he lose his mind and not tell me? You know, there's all these questions come up, and some of those questions, they might be valid, but sometimes they're not, and you would know if you are periodically discussing your estate plan with the people that are going to be directly involved in it.
Can you not? I've seen it on TV, which doesn't mean it's true, but they always say, you know, I'm in my right mind or something to that, you know, upon assigning this will. So is that a thing?
It is. It is. Okay, so there are elements to make a valid will, and this is one of the reasons why I would not say Google it and find a will online, because the elements in Texas might be different than another state. Someone could have put a will to, you know, the internet. No one says, I promise this is going to work on the internet. So if you find something and it's not right, how would you know until after the fact? But there are elements that make a will effective. One of those is called testamentary capacity. You can recite that you do, in fact, I'm in my right mind. I know what I'm doing. I'm executing this document under my free will. That's part of the testamentary capacity. So that part for TV is true.
Okay, this is also something I've seen on TV.
Okay, good.
People will write like their will on a napkin. Or like just a piece of paper. Is that valid?
It depends. Okay. I saw this question on your, you know, interview questions, and I was like, oh, I cannot wait to talk about this because it's so interesting. It really is. So when you have a handwritten will, it's called a holographic will. Holographic wills are admissible in Texas. So you can write something on a napkin, and if it meets all the elements of a will, it could be probated and effectively control as your last will and testament. The problem is, most people do not know all the elements to make a will valid. They might not be thinking of all the ways that a will should make some decisions or give some direction, and therefore when they leave it out, it opens up a larger problem, a bigger discussion, and anytime there's any unknown in the estate, you're going to have a judge help. If two people think they know what's best, you're going to have two lawyers and you're going to fight in front of a judge. And when you hear that, think attorney's fees. Right? Okay, so is it really worth it to save the couple $1,000s and write a will on a napkin and hope that it all works out perfectly, that it is perfect, that nobody, you know, claims it's a forgery, that you don't lose that napkin? Is that really worth it if you're going to invest in the future of the people that are going to be left behind? Which would you choose? You know, so I'm not going to say you can't write a will on a napkin. You absolutely can. Most of the time, or in my experience, it doesn't seem like it shakes out the way the person thought that it was going to.
And how often can you like update your will and your estate plan? Like, is there like, okay, you've done it 20 times, that's enough, Crystal?
No, you can do it as many times as you want. Yeah.
Really?
Yeah, you can change your mind as many times as you want. It is your stuff. It is your plan.
Yeah.
If you want to sit down, but I promise you there are attorneys that would welcome the hourly fee to sit down and talk about it again, But yeah, you can change it as many times as you want. You can, absolutely, you should always ask questions if you have, why did I decide to do this? What was our thought process here? Why does this document say this? Does this mean what I think it means? You want to make sure that you understand what you have and that it does the thing that you want it to do. Yeah, you can change it as many times as you want.
Wow. Okay. What is a death binder and what goes into a death binder?
I should have brought one. I didn't think about it being on video. I know. I'm so sorry. Okay, but I call it an estate planning portfolio because that sounds a lot better than
it does.
But it can be, you can call it whatever you want. But my estate planning portalios have copies of all the documents that are part of the estate plan. Okay. I also include a little information sheet. It's not legally binding. This is for information only, where the client can fill out my accountant's name is, and here's their address, and here's their phone number. My insurance agent's name is, and there's their address. My 401k is, and you can write all that stuff out because those are things people are gonna want to know.
And you don't think about that.
You don't think about that.
Yes.
And honestly, this came about because my own grandparents are elderly. I've had grandparents that have passed away, and I was thinking, who's going to help my grandmother? I don't live in the hometown that I grew up in. She lives on the other side of Texas. And I was thinking, this is way early in my practice, who's going to help my grandma? What questions is she going to know to ask? Where is anybody going to find this information?
Yes.
And that started me thinking about, okay, if I were representing my grandmother, what would I want my grandma to know? What would I want to help her walk through? What would I want to help her prepare for?
Yes.
And that kind of stuff comes up, I have a safety deposit box at this bank. Your executor's going to want to know that, and they're going to have to figure it out if you don't tell them. Other things like there are prepaid funeral plans that you can do. And this is, some people like to do this, some people don't, but you do have the option where you can plan your funeral for yourself right now and pay for it.
I feel like, and we could talk about that, but I feel like that's such a great idea.
I do too.
Oh my God, because again, when I think about wills and estate planning and things like that, I think about, again, the living, but I also think about the grief that they are experiencing at this time. It's probably the most tragic, worst time in their life, and now I have to plan.
And then you have homework. Yeah.
I got homework. I got to pick a casket. I got to figure out where the P.O. box is, Oh my God. It is so for the living.
It is.
It's for the living. Okay, go ahead.
So let's say you find a cemetery that you like, your family's buried, whatever. Yes. And you can make a plan. You can buy a burial plot, you can make a plan. When you get a copy of that, stick it in your binder. I include little see-through page protectors in the back. So just, if there's something that you think your executive, just plop it right in there.
That is perfect.
Just again, what would I be looking for with someone I love passed away? How could I help? How could I make sure that I did everything that I was supposed to do and do it well? Yes. And help the other people that have been left behind along with me. And I think if you just have this conversation with your attorney, he or she is going to walk you through okay, well, this is what happens. Here's what you could do. I mean, I don't plan funerals. I don't get a kickback from those people. It's just a great idea. And some people feel really, really comfortable doing that for themselves and then saying it's all taken care of. And then of course you pay for it. Then you lock in the price. I don't know if you've seen the price of funerals, but
very expensive.
And that's it can be a real burden on the people you leave behind if they're not prepared for that. So I like the idea of having as many things planned as possible. I just think it's a kind, generous thing to do for the people that you're leaving behind.
I agree. I absolutely agree.
See, it's not as bad as, it's morbid, I'm going to die, I don't want to think about my own mortality. Think about how you are taking care of your family, the people that you're leaving behind.
Yes.
See, when you think about that way, it's very sweet.
It is. And, it's very unselfish. That's the word I keep thinking of as we're having this conversation.
So great. Yeah.
It's unselfish.
That's so true.
I know. Oh my God, yes. So, okay, on that topic,
Mhm.
we all know that we are going to die. Yet people they fail to plan for their death.
Right.
Why do you think that is?
People get busy.
Mm-hmm.
We all know that there's things we should do that was on our list and has been on our list of things to do for months, years, decades.
Mhm.
That happens. Sometimes it's an uncomfortable discussion.
Yeah.
And so you really want to put it off. Don't, but your
Yeah.
urge is to put it off. Sometimes you don't know the answer. If you have, a large family, there are dynamics within that family that make you question, like, what's the best option for my assets, or who's in control, or whatever.
Mhm.
Sometimes just the resistance of making a choice causes people to pause. But just because you're putting it off doesn't mean it's not going to happen.
Yeah.
And I always tell my clients, like, if you are having a hard time choosing, let's get something on paper. Let's walk through, let's talk about all the options. Let's find the one that you're most comfortable with right now. And then guess what? In 6 months, if you change your mind, we can change it.
Yeah.
It's okay. It's not chiseled on stone tablets.
Yeah.
We can update it at any time.
Yeah.
Having nothing is so much worse.
Absolutely.
Right? Okay.
What are secured debts and unsecured debts, and who pays for that?
Okay, so remember, your executor is in charge of gathering all your assets,
Mhm.
paying all the debts, and then distributing whatever is remaining to the beneficiaries of the estate.
Okay.
Just because you die doesn't mean you get out of paying your debts. Okay.
Yeah.
And there's a priority of how those debts get paid.
Okay.
Sometimes there are more debts than there are assets.
Mhm.
That happens, and so there is a way that you can prioritize who gets paid and what. Secured debts are going to be paid first. Secured debts mean that they are debts, and they are there's an asset tied to the obligation. So the best example is a mortgage.
Okay.
You owe money, and it's tied to your house. If you do not pay your mortgage, they will foreclose on that secured debt to pay for the obligation.
Okay.
When you pass away, if you have an outstanding mortgage, they're not going to foreclose on it. You just have to make sure that you pay that debt, or you can refinance to. Usually lenders are more than happy to have a new mortgage.
Mhm.
So if you have left your house to, say, your surviving spouse or your oldest child, they can refinance and make sure the mortgage is in their name, and they can take the house subject to that debt.
Okay.
If for some reason they can't or won't, then you need to either sell that house or otherwise pay off the debt.
Okay.
Because that secured debt has a priority before beneficiaries get the assets.
Okay. So you have to have all of the debts paid off with whatever assets you have,
Mm-hmm.
and then the family and friends get whatever is left.
Right.
Okay.
Uh-huh.
And the executor, of course, can be family, friend, lawyer.
Mm-hmm.
Seems like it would be easier for that to be a lawyer,
Well,
like someone.
There are people that, like lawyers, who
Mhm.
will allow themselves to be named as the executor.
Mhm.
I don't personally do that because an executor has, a whole different set of jobs
Okay.
and duties that, it's just different than your client's lawyer, right? I think an executor should hire a lawyer. They can hire the same lawyer that drafted the original estate plan, or they can find their own lawyer. That is up to them.
Mhm.
But a lawyer walks through that with them. But honestly, an executor has work to do. Okay.
Okay.
They got to find stuff. They usually have to go through the house. Organize things. If you have a professional as your executor,
Mhm.
it is likely that professional is going to charge a fee.
Yeah.
So if you have a certain number of assets, and then you have an executor who is charging a fee to do the job of executor,
Mhm.
the number of assets is going to go down.
Oh, yeah, because you got to pay them.
Mm-hmm. So your executor becomes a priority payment.
Mhm.
Administration expenses, last illness is usually a big expense. Hospital debts,
Yes.
you have to get all of those squared away before you start distributing cash or other assets to the beneficiaries. And that's fair and that's right, and that's what the executor does.
Mhm.
It usually takes, a couple months at minimum to get everything in order, but it's doable. And like I said, the state of Texas makes it extremely easy and efficient for executors to operate and get these things done without too much court oversight. So they don't have to wait a long time to get approval before they do things, and that really helps.
Let's talk about stepchildren and adopted children.
Okay.
Is there a special form for stepchildren and children that you've adopted, or does that you just put that in with your regular estate planning with like birth children?
Okay.
How does that work?
Well, you can, like I said, you can leave your estate to whomever, whatever you want.
Okay.
There are people that have biological children and stepchildren and adoptive children, and they treat them all the same. You say that in the will.
Okay.
I direct that all of my assets are split equally between these people.
Okay.
If you don't have a will and you don't say these are the people that I'm leaving it to, then it depends on the court, the laws in the state of Texas. We call that intestate. Okay. Your natural children are going to receive a portion of your estate. Your adopted children are going to receive a portion of your estate.
Okay.
Your stepchildren are not going to receive a portion of your estate.
Really?
Mm-hmm. That's just the blanket law. If you want to do something different than the blanket law, you write it down.
Okay.
Even if you want to do something that's exactly the same as the blanket law, write it down so you don't have to go through the double administration process.
Okay. Yes.
So you can treat everybody the same. You can give priority to different children. You can leave your entire estate to a charity, give it all away because you don't want your children to inherit anything. That's okay. There's you don't have to do it a certain way, but the law assumes that if you don't make a plan, most people would want to leave it to their surviving spouse or their children. You know, and like I said, it depends differently on if you're married to someone that you don't have children with and you have children outside the marriage. If you've been married before, there are a lot of different ways that make things a little bit different. So don't assume that just because I'm not going to write it down, everything goes to my spouse because I'm married and I live in Texas. That's not always the case.
Yes.
At least talk to an attorney about what would happen if you didn't have a will and you died. That way you know for sure.
Yes.
Okay? You don't have to guess.
Now, why can't, I understand why the biological children get, if there's no will, there's no estate plan. I understand why the biological children get. But why would the adopted children get and the stepchildren would not get?
Okay. So when you are adopted, you had biological parents at some point. Their parental rights are to have been terminated. Yes, right? So they are not your parents, essentially. You've been adopted by new parents. Okay, so those are your two new parents. Stepchildren, you still have a mom and a dad, whether they're married or not, and now you have a stepdad. You don't get three parents.
Right.
That makes sense?
Yes.
It assumes that these stepchildren have a father and a mother who have their own estate plan, and they want to inherit from those people.
Okay.
As opposed to their stepfather or their stepmother. That's what the law treats them a little bit different.
Okay, I see that. Is it ever too late, of course besides death, is it ever too late to do your will and your estate planning and all of the documents that we've spoken about?
No, it's never too late. I would say the only urgent part of it is that you don't know when you're going to go. Right?
Right. And
do you want to spend the last bit of your time here on earth meeting with a lawyer? Maybe you do. I doubt it. I'm delightful, but I'm sure people would like to spend it with their family and their loved ones. Yeah. It does happen where, a situation has occurred where they think that the end is likely or they've been faced with it and they want to get it done as soon as possible. Or, I'm about to go into major surgery and I want my estate plan done right now. Lawyers do those. I do those. But I think a better plan is to make it a priority, get it done, review it periodically, make sure your plan is exactly the way you want it as your life goes on, and then don't worry about it.
You are a will and estate plan lawyer. How long have you been in this field?
I've been practicing for 9 years, which seems like a long time. Thought I was kind of a young lawyer. I guess I'm not. That's okay. So I've been doing it almost a decade. Most of my practice has been here in Southeast Texas. But like I said, any Texas attorney can help write a Texas will. And so I have clients all over the state, and there are tons of really wonderful estate planning attorneys around the state and here in our local community.
Why did you decide to go into this specialty with law?
Well, after law school, I joined a big firm, and I had the opportunity to learn a lot of different types of law and find, really an area that I'm passionate about. I do other types of law. I practice in real estate. I do corporate law. But I would have to say the type of law that makes me feel like I am making a difference and I'm helping people is estate planning and probate. Sitting with a client and having them tell you about their life, the things that they have, the people in their life, the things that they're worried about, that is such an intimate and wonderful conversation. And I feel so honored when people trust me with that kind of information. And whenever I can help them make a plan and I can see it on their face, we talk about it and I say, this is what we're going to do. This is when we're going to get it done. And you're going to come in, you're going to sign it. The relief on their face.
Yeah.
That, I almost have chill bumps.
Yes.
And I feel like I really am doing good work, that I'm doing what God has made me, called me to do, that I can truly help people and help them walk through not only the relief of taking care of something they know they want to take care of, but also walking with people on the other side in grief and in loss and helping them navigate, the difficult parts of that as best as I can. So I know it's kind of mushy, but I really do feel like I was made to do it.
Oh my God. Okay. Try not to get emotional.
Oh my gosh,
It's so bad.
See, and you didn't know that it was going to be such a fun conversation.
Oh my God. I'm gonna have to take Melly out.
Oh yeah.
Yes, you've been amazing.
Oh, I'm so glad.
Okay. So do you get emotionally? I guess there's two questions. Do you get emotionally involved, and do you get emotionally burdened because you're always talking about death, even though we know that the paperwork is for the living. That is the topic, when I die, when I pass away, if I go into a coma or I'm incapacitated. These are conversations that you're always having.
Sure. Well, it's heavy, but it's important. And anything that's important is worth doing really, really well, even if it's hard.
Yeah.
Okay. And I do think that all lawyers, no matter what field they practice in, do carry this weight for their clients. When someone comes to you, and whether there's been a death in the family, or they're dealing with a lawsuit, or there's been an injury, or they've been arrested, they're coming to you with something that is so important to them and is really weighing them down. Okay?
Yes.
You are able to take on that weight, relieve that burden for them, and walk alongside them as you figure it out. That I think a lot of attorneys feel that weight and feel that responsibility, and that's why not everybody is an attorney, and it's a hard job for that reason. But it's so rewarding because when you're able to help people and you're able to give them that relief, that's when you know that you've done a great job for your client.
If someone wants to be a will estate planning lawyer, what is that pathway?
Well, takes a little bit of time, a lot of school, but not as long as being a doctor or anything.
Yeah.
So there you go. So you have to have a college degree, and then
Is that a 4-year degree? Okay.
And then you need to go to an accredited law school. You can go anywhere in the country. And then after you graduate law school, you can sit for the state bar exam. Okay. Every state has a different bar exam. So I'm licensed to practice in the state of Texas. And that's why I say I can help anybody with a Texas will. But I don't represent clients in Maryland. I'm not licensed to practice in Maryland.
Okay.
There's different attorneys for that. So if you want to practice in Texas, no matter where you go to school, you take the Texas bar exam.
Okay.
When you pass the bar exam, then you are licensed to practice law in the state of Texas.
And how long is law school?
It's 3 years.
And so once you pass the bar exam, from there you can just pick like what specialty you want? Do you need to maybe intern, for lack of a better word, in that specialty, or how does that part work?
Well, I do. I mean, you want to be as knowledgeable as you can in your practice area. There are lawyers who do, you know, a little bit of everything. That's great. There are lawyers who specialize. That's great too. It just depends on what they're very passionate about and how they feel like they can best represent their clients. My recommendation is to talk to an estate planning attorney if you have questions about an estate plan. They know the most. They're able to help you with the most recent case law, the changes in the law, and honestly, the benefit of experience. When clients tell me things, you know, situations in their life, and if I'm in a probate and I see how something shakes out, that helps me recommend different things to my future clients. Because like, we might not want to draft it that way because I've seen this happen before, so we want to consider that. I think experience helps your attorney give you the best recommendation and advice they can. Then ultimately, it's you as the client's job to make that decision, and then us to put it on paper for you.
Okay. So we are getting ready to wrap up the interview.
No.
I know. Oh my God, you're the first person who said that.
No, it went so fast.
Oh my God, I loved it. Okay, so what would your advice, your professional, experienced advice be, the most important thing you feel that needs to go in your will and in your estate plan, which I know is the umbrella, but what would you say is the most important thing?
I think, gosh, that's a hard question because it would be different for every client based on what's important to them.
Yes.
So I'll take it a step backwards.
Okay.
I think the absolute most important thing is to find an attorney that you are comfortable talking to. There are so many wonderful attorneys, so many. Everybody has a separate personality. Clients have a separate personality. You need to get with someone that you mesh well with, that you can talk to, that you can ask questions to, and then you feel like you can get an answer that you understand and that you need. If you know, are in the market for an estate planning attorney and you have a consultation with one and it just doesn't seem like the right fit, that's okay.
Okay.
Find another one.
Oh, okay.
Yeah, you're not tied to that person for life. You are the client. This, as a service industry, I work for you.
Right.
If I'm not meeting your needs in whatever capacity, you can find alternate representation. And honestly, I would want that because if I'm not meeting your needs, if I'm not servicing you well, then I want you to find someone that is. You know, a lot of attorneys get a bad rap. You know, we're the worst. We're not nice. But there are so many wonderful attorneys that want to help. Yeah. And you just need to find the right fit for you. So I would say more than what goes in it, it's who you're talking to. If you get with someone and you just really don't feel like you're understanding what they're saying or they're not understanding what you're saying, then just find one that you work well with.
If people want to, and I suggest that they do, if people want to reach out to you and talk to you about all the things that we discussed or bring you on as their attorney, how do they do that?
Well, currently I'm not taking any, so it's December. So if you're watching this podcast at a later time, things may have changed. But currently I'm not taking any new clients. But I am always able to tell the client, you know, directly, I am available or I'm not available. And you can just Google, you know, estate planning attorney Sara Norman, and you will find me.
Perfect, perfect. And my final question for you, Ms. Norman, who do you think will make a great guest on the podcast, but you have to help me get them on?
Okay, I prepared for this, and I'm ready, and I think it's going to be a really good guest. Her name is Nikki Messina. She's with Guaranteed Rate, and I think she would be an excellent guest because she's the kind of person that is so conversational and so personable, but has a huge knowledge about the real estate industry, mortgage rates, lending, you know, some topics that people are kind of afraid to ask questions about. And she has an extensive knowledge and is so wonderful to talk to and work with. So I recommend her, and I already called her.
Thank you. And thank you so much for talking to me about this topic, because again, most people, and when we spoke on the phone, most people, they don't want to talk about death.
Right.
They don't want to, think about their own, mortality or their children, what's going to happen to them if I pass away, or my husband, or they don't want to talk about it. And I get it, but it's not for the person that's passed away. It's for the living.
Yeah.
So thank you for having this conversation and being so passionate and excited about it.
I'm glad that came across. I really am.
did.
I'm passionate about it. I want everybody to know that they have options, that they can make a plan, and it doesn't have to be scary or sad. It can
Absolutely.
be exciting and it can be relieving.
Yes, yes. So thank you so much,
Of
Sarah.
course, happy to be here. Thank you.
And thank you so much for tuning in and watching. You can get this podcast and all of my other podcasts on YouTube Podcasts and Apple Podcasts. And remember, you always have time to listen and learn on the go.
Robbie Crystal Petrie Console.